everybody. This is your good friend, the Safety Doc, from down here in the North Star recording studio. Yes, in Wisconsin, it's cooling down outside, but it's hot down here in the studio, which is good news. And I've been flying solo here for some shows, and today, though, I have a special guest on, Lisa Linney. Linney, as in knee. Linney is an attorney at Murphy Legal in Texas. Her focus is motion practice. So one of the things with motion practice, remember, if you're Houston Astros baseball, it's a double slide, first to second, second to third. Motion practice in appellate law. Lisa's appellate practice begins before a case even goes to trial. She participates in trial preparation by researching thorny issues and crafting motions in support of her clients' positions and to preserve the trial record for any potential appeal. Lisa also handles appellate work, including briefing and oral argument. She is a graduate of Northwestern University Pritzker School of Law. Welcome to the show, Lisa.
Thanks, David. I'm so happy to be here.
Wow. I'm also thrilled to have you on the show. And I met Lisa after watching the Old Humble Distillery podcast. Old Humble, Humble, Humbl. It's a city in Texas. Old Humble Distillery. Lisa is a co-host on that show with Joe, and I learned of her legal background and was like, whoa, she would be fascinating to have on the show. We also talked, I teach legal issue courses at a university in Wisconsin. I was assembling some case studies, and she helped me out with that. So thank you for that, Lisa. So how is, well, it's the day after Halloween. For me, this is kind of a letdown because Halloween is my favorite day of the year. So when you get after Halloween, the TV shows, the Travel Channel, they kind of ease back off of the ghost shows and Haunted Gettysburg. And I miss that. But tell me about your Halloween.
I bought a lot of candy. And I did that on Friday. And I, tried really hard from Friday to Sunday to eat just about everything with caramel in it. And so I filled up this big pumpkin-shaped basket of candy. And I live near the University of Houston. It's an urban neighborhood. I've never seen a kid on my block. But there are two high schools there are schools nearby.
Okay.
So anyway, I put my house on the treat map in the Nextdoor app. And I got one group of a half dozen sophomore high school students come to my door. And
that's awesome.
They were so cute. Like the tallest one knocked on the door. It was like, trick or treat. He's got his mask on. And you can see he's peeking into my window. And so I hold the pumpkin basket out. And it's like, I'm so glad you're here. Hope you guys are having fun tonight. And the first kid reaches in and takes one piece of candy out. And the next kid reaches in and takes one piece of candy out. And I'm like, y'all, what's with this taking one piece of candy? Get a handful. I do not need this candy in my house. And so all of a sudden I have all these hands going into the basket. And they were really excited about it, that I was giving them so much candy.
That is so cool.
Yeah, they started walking off, and I put the basket down. I was like, I need a photo of my trick-or-treaters.
Yes.
So I grabbed my phone and shut my front door and go jogging down the street, waving and yelling at them. So anyway, yeah, I got a photo of my high school trick-or-treaters. So they were super cute.
So how many total trick-or-treaters did you have?
That was it. Those 6 kids were
okay.
it.
6 kids.
So
wow.
They came, I want to say it was about 8:30.
Which is in trick-or-treat. Okay, so that's pretty late for trick-or-treating. Yeah.
So I cut it off at 9. I turned the light out at 9.
Wow. Okay. So what are trick-or-treating hours where you're at?
I don't know. I
Okay.
mean, I would. I mean, it gets dark right now before 7. So,
Right.
like, if you've got a little kid, I would think that you probably feed them and head out the door at about 6 o'clock.
Okay.
So, but at least the weather was nice last night, like in the 70s, really mild, no rain.
Wow.
Yeah. So,
So where I live, we live close to the school campus in town, meaning that the elementary schools, the middle school, and high school are all in this one area of land. And we had 800 trick-or-treaters last night between 4 and 7 p.m., which isn't unusual. It's on the high end, but it's not unusual. You prepare for that. Um, and what was so next to us is the neighborhood that gives out the full size candy bars, like a block away. The kids come up and then we give out, the two fun size, and they're like, okay, like what else? I'm like, this is it. Come on, it's experience here though. Like I put the skeletons out for you, and I got the bloody leg under the
under the
garage
garage.
door, and like I put time into this, right? Like, and so and yes, but it's fun. I mean, it's my favorite holiday of the year. And there was a kid, maybe like 3-4 years old, who was done up as Beetlejuice. Perfect, like Michael Keaton, like spot on. And I was like, this was amazing. Just the detail that went in, and the kid knew how to kind of play off the Beetlejuice vibe as he was coming up to the house and stuff like that. Was awesome.
Wow,
Um,
cute.
but yeah, and my daughter was out trick or treating with her friends, and it cooled down substantially. So maybe it was like 48 when they went out, and was about like 35 when they came back. And it was not raining or snowing or anything. We've had that happen here. When they came back to the house, I started a fire. We heat our house with wood, but we live on top of a hill, so the white smoke is coming out, and then it's coming down into the valley, and the kids get the whole haunt experience of. Or they're like, "Is there a new pope that's been named?" or something like that. I'm like, "No, no," but so yeah, pretty wild stuff. But so anyway, Halloween, scary stuff. Some scary stuff can be dun, 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 litigation. And today's show title is COVID Chaos Parents Sue School Districts. Special guest attorney Lisa Linney. So this is happening here in Wisconsin. We've had multiple instances now where parents have sued school districts saying, you did not keep my child safe, and my child caught COVID from the school setting, and you needed to do more to mitigate that. So school, you have responsibility in this. There's also a weird variable, and we have a PAC, which is funding some of these lawsuits, and that's been in the news. But nonetheless, multiple districts getting similar lawsuits or receiving them. So I teach legal issue courses for school superintendents, aspiring superintendents, and aspiring special education directors, school leaders. This is a topic we've been talking about because some of them have been in districts that have received these lawsuits. So what we're going to do today is talk about what happens when a parent sues a school district saying, hey, my child, for example, caught COVID, and I think you're responsible for it at school. I believe it happened at school. What happens behind the scenes? What does a school do when they receive a lawsuit? What does this look like if it's, once it hits the courts? What might be a parent's strongest argument or a school's strongest argument? Because we're seeing a lot of this in the news. Like I see it in the newspapers. My students are asking about it in class. I'm seeing it on national headlines, and I think we'll see more of this. So just to get people familiar with how these arguments are kind of framed and how schools and litigation kind of operates in this regard. So, so again, the purpose of this interview, and I do have as I'm looking here at everybody in the audience, let me give a few shout outs to our good friend Bacon Maldito in Inglewood, California Bacon, Maldito, and Inglewood, who is he's championing for a Dismore's IGA in Inglewood, and I wish him the best because the in-store deli's awesome. They have strong Wi-Fi, great deals, but it's an uphill battle, buddy. I don't know if they're going to leave the greater Washington area, but keep going. Fight the good fight. Dismore's IGA.
And it's what?
It's Dismore's IGA is in Washington State, and our friend Bacon Maldito, who's in the chat, lives in Inglewood. So he's hoping that they will branch off and come into California.
Oh,
so
that's a supermarket?
Yeah.
Gotcha. Yeah. Here in Texas, we have HEB.
Okay.
And oh my gosh. I lived in the Dallas-Fort Worth area for a while, and there were no HEBs in the city. They were all out, like way far out in suburbs. And I lived there for a little over a year, and man, I missed my HEB. So
Really?
Oh gosh, yes.
Okay.
So yeah, they have a lot of really fantastic products. They do a contest where they ask customers to come up with products, and then they put them into production. And
that's awesome.
Yeah. So some of them have like these cooking stations where somebody's basically teaching how to make a meal. They have fresh sushi. They have, great cheese selection. They are the largest wine purchaser in Texas. And so good. So good. So yes, I understand this longing for, one of those spectacular grocery stores. So
it sounds like a challenge to Dismore's.
Yes, I would absolutely.
My goodness. I want to give a shout out. We have a listener from Germany. Yes, the country of Germany right now. Phil Henry is in the house. Phil Henry in Germany. He did show me the multi-station radio interface thing that he has to go through in order to get the international shows. It's quite a feat. But Phil Henry, who is friend of the show and is also a friend of the Nailman statues, which are mentioned in my book, The Velocity of Information, coming back to Austria in World War I. So it's kind of an obscure reference, but if you do want to do an internet search, Nailman, World War I, you'll understand what I'm talking about with that. And Joe Dolio is in the house. Joe, I listened to your entire podcast. Your interview with Brooke says America or Brooke, and I didn't hear your shout out to me, buddy. So I don't know, man, if I got to listen again, or it was an hour and 12 minutes, but I was listening for the old safety doc shout out. So you might have to point me in the direction of the other show, because I think you said you gave me a shout out. But great show. So we have people coming in here, and yes, Phil. So Phil is he's keeping it balanced here. He's going to give us an update on what is happening in Germany here at some point. But right now, purpose of this episode, again, we're going to understand what happens or go through the pieces when a parent sues a school district. So this type of litigation, again, is happening in my state here in Wisconsin. It's making the news. And this is the statement that seems ubiquitous across lawsuits. Here it is. The school board and the superintendent are not providing a safe environment. The school board, Board of Education, and superintendent are not providing a safe environment. Right away, a disclaimer. This show is for entertainment purposes only. This interview does not constitute legal advice. It does not presume fault or specific actions have been taken by school districts or potential third parties, which might have some responsibility. We're not going to identify districts by name in this, and Lisa's going to talk in generalities, right, and kind of just how behaviors happen in litigation. So yes, don't take this as your exhibit A when you prepare to be involved in litigation, but this will bring some sense of what would be familiar when you start hearing terms on the radio or people talk about what is an accelerating area of litigation here in Wisconsin. So a few things. One is when we talk about school districts, for this show, we're going to kind of talk, school districts will represent a board of education that's elected by the public, board of education members, who typically, by the way, make $3,000 or $4,000 a year in Wisconsin. And I say that because I've seen people who are saying, well, we'll take away the pensions of the board of education and all of this stuff. I'm like, they make about, $100 a meeting or something like that. It's not much. So your board of education, and they create policy for your school. Your school policies come out of board of education. Then your superintendent is the person who runs the school, is in charge of the school. You can also have some other people in that line, such as principals, right? Teachers and things like that. But really, when we talk about school district, we're going to talk about the board of education, which makes policy. And that's your school board meetings, and then the superintendent, who is in charge of the school and kind of making sure that those policies are implemented. So let's go through this. Lisa, right off the bat, I'm using the bat analogy a lot because it's baseball season, World Series. You're in Houston. Houston Astros are playing the Braves, who used to be in Milwaukee. I'm in Wisconsin, and they won a World Series. And so these connections are there. They're very much identified tonight, this baseball theme. But what happens? How does a district know that they've been sued? How are they notified?
So typically there will be a legal officer for the school district, or like a main office for the school district. I mean, the school district is going to have, except in very rare cases, they're going to have like a main administration building, and process server is probably going to walk right up to the front door and say, "Here you go. Please sign here." So it's not, when you have an organized institution or business, if there's a physical address, then it's pretty easy to get them served so that they have notice.
So serve has to be in person?
Nope.
Okay.
At least not in Texas. In Texas, you can serve personally, by mail, by fax, by email. Well, not email, but there's an electronic service that you can go through that does populate somebody's email. So, and you can also do it by publication in certain circumstances. But generally personal service is used. And for businesses, there's typically a corporation that accepts service. There'll be a registered agent, is what it's called.
Okay.
And they'll accept service on behalf of a corporation that may or may not be located in Texas. So there are a couple of different companies who do that. But like I said, if there's a main address, then it's probably going to get delivered to that address. So either, by personal service or likely certified mail.
So yesterday it was Sunday, so it's Halloween, but to deliver on Halloween would be kind of a weird trick or treat type thing. Trick or treat, you've been served.
Could be done, but your school administration building is probably not open on a Sunday. So, but I would imagine that there's been more than a few divorce cases that have been served that way.
Lisa, when I was a school administrator, some of my close friends who are also administrators, we went out golfing, and we had a picture taken of the four of us. So I had it made into an 8x10, and I sent it to each of them. But I sent it certified mail in a mailer that I had a false legal company up in the top, just fabricated, right? That didn't exist. And then on the envelope, it said, due process lawsuit, open immediately, like in big, it had labels printed off, and I had like their names, and immediate, one of them said I was in a meeting and I got called up by my administrative assistant, and she's like, you have to open this, like this is your name. And of course it was just, I sent them the picture. So it was a good spoof. But yeah, each one of them, like that day, got a hold of me and was telling this scenario where it quickly worked its way through the mail room and all of this stuff and got handed to them. And then they're all like, oh God, no. And then open it up. So, but it was, yes, a fictitious email address up in, or a return address up in the corner. So, but yeah, it's a little prank here from the safety doc, right? It was good friends. But yeah, my friend Tim will never forget that though. He's like, yeah, so like everyone was just like hovered around him, like, open it up, open it up. So, well, what happens if somebody receives a lawsuit? Like what immediately, and let's think about schools. What probably happens like in those hours after they receive that they've been served?
So, what should happen is they should give that to their legal counsel, whether that person is in house or at an external firm, so that that person can review the claims that are in the suit and then decide on some preliminary strategy. The first thing that has to happen in the suit is um, to answer it in some form. So there are a few technical issues that you can try and get rid of the suit without actually filing an answer, but um, in these cases, that's probably going to be really rare. So, I mean, the first thing that needs to happen is to answer the suit, and the timeline to do that, at least here in Texas, is about 3 weeks. It's like the Monday following. It's 10 a.m. on the Monday following 20
Right.
days, and if that Monday is a holiday, then it's on the Tuesday. And anyway, so but I don't know what it is in Wisconsin, but generally, it's a fairly short amount of time that you have to file an answer. And the reason for that is you have to prevent a default judgment.
Okay.
So basically what that is if the school district doesn't answer and make an appearance in the court, then a judge can order that the plaintiff wins by default because nobody bothered to respond.
So it's one of those things of saying, covering your ears and pretending like it never arrived, and just like, and it's like, that doesn't work.
No, don't be the ostrich.
So, okay. So there's this, let me ask this question. So, in Wisconsin, these lawsuits have two components to them. One is it states that the plaintiff, the parent, is seeking declaratory and injunctive relief. So those two, declaratory and injunctive. So what does that mean when that appears on the lawsuit?
So declaratory relief is asking the court to declare something. So in this case, it may be to um, declare that masks are mandatory, or declare that the school district should enforce their mask mandate, or it's it's an affirmative and it's an affirmative statement basically, which you'll see contrasted with injunctive relief. Injunctive relief requires someone to stop doing something. So, um, and if I guess I'm trying to think of what they might be asking for in injunctive. Have you seen anything specified under injunctive relief?
So my interpretation on this for injunctive relief is that you have to stop a lot. You have to stop allowing for discretion of mask wearing. Like it has to, you have to remove that discretion and say, we are requiring you to wear a mask in our schools.
Right.
And then I've interpreted the declaratory to kind of be this maneuver of trying to pressure, get enough pressure on these districts where they're trying to get the state to jump in and make a decision and say, okay, all schools, people in schools need to wear a mask. And
And that
um,
may be the intent of
yeah,
it, but the court can only the court can only impose the declaratory relief onto the defendant party. It
so
can't say like, you've got one school district. That's going to be the only school district it applies to.
we have 421 districts in our state, and one is on an island. And so what you're saying, Lisa, is this will apply to that one district which has been named in the suit.
Mhm.
And so what is happening is the PAC is supporting multiple parents in multiple districts to litigate this identical suit. And I've looked at the lawsuits, I've downloaded them. They're virtually identical word for word.
Mhm.
And the PAC has said that. And the PAC is trying to build pressure. I mean, publicly they've come out and said this. We're trying to build pressure to have a state response on this, so we don't have to go and keep going into, now it's 5 districts and 10, then 20, then 30, then 50, and whatever it would be. But in trying to get the districts, and I think to pressure onto their legislative bodies or their Department of Public Instruction, things like that. But okay, so declarative. One more time, how would you?
Declaratory relief is like the court would say that a district has to do something. So, and then injunctive relief is telling the district that they can't
Okay,
do something.
so in this case, declaratory could be you have to have students and staff wear masks. An
Yes,
injunctive could be like that you can't have this as a self-discretion type
right,
thing, wear it if
right.
you want to. Okay, got it. Um, so how about this? Our board members, so boards can have anywhere from like 5 members up to 11. But Board of Education, are the members and the superintendent, are they usually represented by one legal counsel in a lawsuit, or are they going to seek out their own legal counsel, or are there times when they kind of, split and decide, I'm represented by the school, but I should also receive my own legal counsel? What kind of goes through the mind and the processes of a board and a superintendent when they receive like this type of litigation?
Well, first of all, if a board member or a superintendent is named in the suit, they are generally named in their official capacity as
Yes.
a board member or as an employee of the school district. If someone should be named in their personal capacity, um, there are there are motions that can be filed in order to resolve that and saying, look, this person, there's a concept in jurisdiction called standing and capacity. And, someone is sued personally. That's not the way that these parents can get relief. There's no personal liability
Right.
imposed on a superintendent unless there is some sort of special duty, which I can't imagine there would be in this case. Um, unless a superintendent has made some sort of representation to these particular parents. Um, so, there's that aspect of it, is the official capacity versus a personal capacity. The next thing that I would look at is where their insurance coverage is.
Yes.
And under what policies, are they? And are these policies with the same insurance company? Are they with separate insurance companies? Because you're going to have, you're going to have coverage for people who are serving as the school board members. And you may have the superintendent on a separate policy because he's an employee.
Right.
Oftentimes, so a school district insurance company, because of those insurance policies, included in those policies is generally a legal defense. They'll have a duty to defend these parties under those insurance policies. So if you have if you have one policy for the school board and one policy for the superintendent is covered, whether they are with separate insurance companies or the same insurance company, if they're with the same insurance company, they're generally with different claims handlers. So there will usually be a conversation to figure out, okay, how are we going to coordinate this defense, and do we just hire one law firm for both? But somebody's going to have to do to see if there's any conflict of interest between the school board members and
Right.
the school district. Right offhand, I can't think of any that there would be. But it's possible. Like perhaps the mask mandate didn't come from the school board, but maybe it came up administratively.
Right.
So that would be an example of where the conflict is. And so, you may have, and it's not really a conflict. It's a way to get the school board members out of the lawsuit, and the same attorney could handle that. So, and there are various mechanisms of getting a party out. Generally, a motion for summary judgment is what you're going to be looking for.
So in the lawsuits in Wisconsin, this hasn't occurred with one of the districts that's been the recipient of lawsuit, but this did occur in Wisconsin. A school administrative team, meaning the cabinet, director of instruction, special education, health services, and a superintendent, recommended to the school board in open session that the school board adopt a full mask mandate. The board voted against it and said no. So in that case, now you have a superintendent who has brought forward information to inform a school board, and the school board is deciding to act in a different direction.
In that case, they probably want separate legal counsel.
Okay. So that's something where one of the things that I share in my courses, again, I am not an attorney, but I have been an expert legal witness and was a school administrator for 20 plus years, and advise my aspiring superintendents and forth to get a consult from an attorney if they are named in significant litigation. Just because there can be situations like this, and I've experienced this as an expert witness, where a board of education and a superintendent kind of split in in the process of litigation saying, well, this is what the board was doing, and this is what or the board can say, like, we voted this in and the superintendent didn't carry it out. The superintendent, he or she, didn't meet with the principals, didn't put together a plan for professional development on this, and the fact that this didn't happen in the school is on the shoulders of the policy wasn't enacted by the superintendent. But yeah, so we're starting to see some interesting kind of splits right where there should be a seamless portrayal from the district, right? The district should have the same pay. The Board of Education and the superintendent should be aligned. If they're not, as I tell my superintendents, like, you should start looking somewhere else for a job, because it's not going to be good for you in the long term if you're Board of Education.
They are going to throw you under the bus at some point.
Right. Substantial. And they'll separate. And what's happened in those cases.
See what I did there?
Right. They separate out, and then they'll say, yeah, you were acting outside of your role or weren't fulfilling your role. So it can be messy. So I spent the part of my time today talking with some of my superintendents, one directly involved in this, and then also talking with some legal representation for freedom of information, which we'll get through later. But yeah, so. Right. Well, let's go over and check the chat room, by the way. Phil Henry is holding down the entire country of Germany. So he has a 7,000 watt antenna on top of his house, which draws attention from the neighbors during the day, but at night it's okay. But during the day, yeah, there's some questions. But yes, so Phil Henry's in the house. He says, a question: if students go to school, there is insurance for them, health accidents, ambulance. Yeah, schools do have that policy. Is this covered by the state, or does it have to be bought by parents? So in Wisconsin, so example is the kid is in Phy Ed class, and they get knocked out because they fall off a scooter and hit the wall or something. Innocent accident, right, during gym class. And what does it look like for school insurance to cover? In Wisconsin, that's paid for by the schools. But then if there's cost of making the student whole, I guess, which would be dental work or things like that, I assume that goes to the parents. It's a good question. Like, as a school administrator for 25 years, I have no idea. But we did have errors and omissions and general liability insurance for the school. But that, something like that is an accident. Usually that's that or recess or something like that. But yeah, I don't know if you want to add anything to that.
Yeah.
Sure.
The accident happens, but generally the child's parents, their insurance would be the one to, like, when the child first gets treated, they're going to ask for their medical insurance, and then that treatment cost is going to go through their medical insurance or their Medicaid, the state and federal government supported insurance for low-income families. And then, in a low conflict situation, those costs would get basically charged back to the school's insurance policy.
Okay.
The health insurance policy is probably going to ask for a right to subrogate, which if the parents sign, then they lose their right to sue the school district, and the insurance company either works out a settlement with the school district or they sue the school district for the cost.
Wow. Actually, I dealt with it very little in my time with a school.
Good.
Yeah. I had one situation where a student left the school and in the parking lot threw a rock and damaged somebody's car. And then the parent or the owner of that vehicle was trying to get the school to pony up the money for that. And the school said no. But so I don't know. That's why I always say live in a desert. It's just sand. When you throw it, it just kind of dissipates in the wind. We do have a great question that came up in the chat, and I want to.
Well, going back to the scenario where you have a kid throwing, so car was on school property.
Yes, in the school parking lot. Yes.
Okay, and then kid throws a rock and causes damage. So it generally a person, which would include institutions like schools and corporations and things like that, they do not have a responsibility to keep a third party from acting. So um, children are generally liable for their own torts.
Yeah.
So in Texas, there are a few special exceptions to that. But I mean, your school was probably right in saying, no, it's not our fault. So we don't have a liability here.
I think what happened in that case, Lisa, is the person whose car was damaged knew the child, not through the school, but knew the child that damaged it, and then contacted their parents. And then I think it was just like okay, what are the damages to get the dent removed? But yeah, so then the school wouldn't be responsible for the third party actions of the child unless there would have been some foreseeable, for example, a student with disabilities, a special education director, and that might have had a history of throwing things on a playground or something like that, and then to not properly place that student on a playground or to mitigate that. Or am I thinking too much into that?
There is probably not a duty there.
Okay.
Like I'm actually working on a similar issue right now, and parents are generally not responsible for their child's torts.
That's amazing.
Yep.
Okay.
So, but like I said, in Texas, there are certain exceptions to that, but they're pretty narrow.
Okay.
Now, there is a tort in Texas for negligent supervision of child, which would play into this scenario here if possibly. But in Texas, that tort is narrowly defined by parent. So there is a legal definition of parent in the statutes in Texas. So again, like if someone were facing this issue in Texas, your special education director would not have been the person responsible.
Wow. That's amazing. I didn't know that. This is one of the reasons why I advise my students before the start of the school year to sit down and to assemble questions for their district council, just kind of a one-on-one. And this would be a question, that might come up, right? Who would be responsible, and to have that answered ahead of time. So let me run you through this scenario. Superintendent arrives at school the day following that the school has just received the lawsuit about from a parent. My child caught COVID at school, is in the alleged in a lawsuit. Superintendent tries to log in and it's like, my password's not working. Tries to get to Google Drive. Google Drive's not working, and finds out I'm frozen out. I'm named in the lawsuit along with the Board of Education, frozen out of access. So that's happened a couple times. What is probably happening there? Because it freaks people out, but what's really probably happening in that situation?
Likely what's happening in that situation is that council has instructed IT or contractor to gather data. Um, it's easiest to do when there's no data being added at the time. Um, so because there's an obligation of parties involved in the lawsuit to not destroy or tamper or alter evidence. And the concept is called spoliation. So you have a duty not to spoliate evidence. And if you do cause spoliation, then a judge can order sanctions and they can be very severe. There is something called a death penalty sanction, which basically obliterates your case. Like you can't use evidence. It's a very important thing to. It's very important to preserve that data up, not only up to the point where the lawsuit is filed, but also afterwards as you're creating new data to continue, like in discovery, you'll have to continue to
Right.
provide data going forward as it um, as an obligation to supplement your discovery responses. So, um, I would caution whoever has found that they're locked out. I would caution them not to jump to conclusions just yet. That they're probably you're thinking they're going to be escorted out the door with their little cardboard box, but um, probably not what's going on. So
So,
not out of the realm of possibilities, but
so, so, just as you indicated, in the situation where I was talking to the school administrator, what was happening was the school's legal counsel, so they had been informed of the lawsuit. They immediately contacted a sub agency to come in and meet with IT and basically do a backup of everything that was on the district's email server, all of that, and then they would operate from that backup where they would pull information for the lawsuit. The thing was, it wasn't clearly communicated. So as the soup came in, and other people were kind of like, "Hey, like I'm having some trouble," or the system is, it wasn't put out there, and so that was part of the communication that didn't come from either the legal firm or briefing with the superintendent or PR. And it can be kind of weird too, because right, if that gets out to the media and they're like, the district shut its internet down or their servers down for 3 hours today, as it just seems weird. Like that doesn't. But what is happening is there's this copy that's made, and then from that copy, things can be harvested, and then once the copy's done, things can continue. I remember working as an expert witness with a district that after they were served, they came out with a brand new edition, like in hours, of a handbook and got it up on their website. And they're like, "Here's our handbook." And I was like, the council I was working with that time was like, "I'm not sure this is a handbook. Like, this is not what parents are saying is the handbook. Like they're saying something else was up there a few weeks ago." So it was this trying to afterwards change the fact. But so they're trying to capture everything and have a record of it. And in the time that happens, what so if you were legal counsel working with some organization and they were just about to undergo this kind of temporary freeze of files and this making of a copy, how would you tell people that so they wouldn't freak out? Like, hey, you're not going to have access to your email and your drive for 3 hours. So they're not like, "Oh my goodness, like I'm in trouble. Like this feels really bad. This has never happened to me before. I'm scared." Like how would you suggest that information comes out to people in an organization?
So I think one of the easiest ways to do that is or one of the most sensible ways to do that is to call a meeting and explain what's going on during in this meeting. At the same time is when you are freezing the system to start preserving the data, so that nobody has any sort of idea that they need to, dump all of these emails
Right.
or
Right.
something. So, um, but that's how I would do it. Say, there's a mandatory in-person meeting in the assembly room. So at such and
Just
such time, about 10 minutes into that meeting is, when your IT or your, contractor is supposed to start, you know, locking things down and
yeah.
pulling the data.
And that's a great point because that is the step that isn't happening on the school side. They're not communicating that out to their employees.
So everybody thinks you're going to get fired, or that they
Everybody thinks
have
they're going
all
to
of
get
their
fired. Like
lesson plans for the year. And
they're like, yeah, everything that I ever emailed my NCAA bracket, is the school NCAA bracket. I'm going to get busted for that. I mean, everybody goes to the absolute worst case scenario. And then they frantically, try to build up their own defense and preserve whatever they can. So I've seen that as a complete kind of letdown of how schools should be advised by their not only legal counsel but maybe their organizations that they contract with, their state school board associations or things like this, of because they have these entire departments that just work with public relations, right, on different school things, or school funding, or also kind of crisis management. If there's been an incident of a death in a school or something like that, they contact with these PR agencies on how to make sure the school is communicating that out. But when things like this happen, and it's new, right? Because how many pandemics have we been through? Like for me, this is only like the 7th or 8th, but for a lot of people, it's their first. And how do you communicate this? So schools are kind of fumbling. And here in Wisconsin, 421 school districts. Most of those have under 1,000 students. So your superintendent is probably your athletic director, and maybe overseeing some other things too. So, this is a step right away of talking with legal counsel and saying we have to let people know what this process is and why it's happening. It's to preserve this set of information, because right, and it's strange, Lisa, because like no one has reported to me that that's how this went down at all. They're all completely into freak out. System is froze. I think I'm in trouble type of mode. So that's been my advice: is one, to let your staff know. Also, if anything happens like this, it's happening in the state right now. So if we get named in a lawsuit, this might happen in our district. You might have a time where limited access to files or whatever. We don't know, but and if you tell people ahead of time, they usually handle things better than if you spring it on them in the moment.
or if you don't spring it on them in the moment, they just figure it out. It's like, oh.
It is. And, as a school safety expert, when I work with districts, one of the things that I tell districts is, which is kind of an aside, but this is very important, is if there's a school shooting at your school, convey this to staff at the start of the year in service. You're not going to be able to access your classroom or the parking lot that day. Like that's a crime scene. Like all of that will be off. And, there'll likely be transportation arranged for you and things like this. And I say that after working with districts where once the event is completed, people expect to be able to go back to their classrooms and get to their cars, and they can't. And they really have a substantial negative reaction to that. They've already gone through this traumatic event, and now they'll be like, I'll do anything, like, to just have my car and just to be able to drive home and things like this. And it's like, no. And so that's where I think, and I'm going to make a point of it in the blog post, is to let people know that if this does happen, if the district is a recipient, the data, the base, there'll be this copy likely made, and that will be guided through the litigation or through the attorney has a subset, kind of like an IT attorney division, right? Is what we were talking
No,
about.
not necessarily. Probably
Okay,
not.
well,
So there are, within the legal industry, there are companies who will, copy this data and put it into
somebody with a thumb drive. So, okay.
and if it's if it's quite voluminous, with which a school district I would expect it to be, then they will dump that data they'll dump every file into some sort of document management program. And then they will, at least in Texas, they'll hire licensed attorneys for about $25 an hour to sort through those documents to see what's privileged and what's responsive and what's, irrelevant garbage.
Okay. So that's the behind the scenes, is this data then is being sifted and winnowed, and also for freedom of information requests, later. So, okay. So right now, we have a plaintiff, we have a parent suing a school district, we have the school district board of education and superintendent. But there's this concept you made me aware of, responsible third party. And this has come up from several of the superintendents I've spoken with, and they said, hey, like, we feel that there should be some other people at the table on the defendant side, the county, human services department, at least in Wisconsin, at the start of the pandemic and throughout the pandemic, was supposed to give guidance to schools on mask and contact tracing and that. And that seemed to happen initially. And then there was a lot of pushback from communities. For example, saying, my child's attended this basketball game. Now everybody at the basketball game was notified they have to stay home for 2 weeks or whatever. And some of these counties have said, no, we're not going to do it anymore. District, it's up to you. And in one of my situations, one of my school administrators showed me that the county just gave him access to the database and said, here, you track it on your own. And so, I'm looking, and he can bring up anybody's name and their address and stuff. And I'm like, well, you're not supposed to have that access. Like, that's really county reserved access. You could, but he's doing the best he can in that situation. So right now, some school administrators are saying, hey, county health services should be part of this for not appropriately informing us. They're also saying the Department of Public Instruction didn't come out with a blanket statement, or at least their guidance hasn't been sufficient. Basically, they're saying,
is that a state agency?
Yes.
Okay.
Yeah. Which oversees all districts in Wisconsin, our Department of Public Instruction. So those are the two informally that superintendents are saying to me, we feel that we haven't received sufficient guidance from these organizations, or that we received stronger guidance at the start and then it diminished, during the pandemic. So basically asking, well, what responsibility might they have? So tell us about this whole thing of responsible third party.
Well, there are two ways to attempt to pin this on these other external parties who were not sued by the plaintiff. One way would be for the school district to file a cross claim against the county or against the state. And that would bring those parties into the lawsuit.
Okay.
And they would need to participate in the lawsuit, participate in discovery, and
so Lisa, that would be the district then filing a cross claim? The district? Okay.
Right. So, and in that situation, if the plaintiff recovered, and here we're talking about declaratory and injunctive relief, which is not monetary, but say that the parents were also suing for the past and future medical care of the child, then you've got three parties that are potentially on the hook for that judgment, in whatever percentage proportions that add up to 100. So that's one way. The other way is for either the plaintiff or the defendant to designate the county and or the state agency as a responsible third party. So what the responsible third party is, it doesn't bring that organization into the lawsuit. They don't become a defendant. It's what's called the empty chair.
Empty chair. Okay.
Yeah. So the responsible third party is the named defendant is going to, try and shift as much of the blame onto the responsible third party. And so when the decision goes to a jury, you'll have, you know, plaintiff, defendant, third party, county, and then state agency. So the liability gets divided up between those four entities. And so let's say that the plaintiff recovers $1 million for the medical care of their child.
Okay.
That's what the jury awards. But that is divided into 30% against the school district, 30% against the county, 30% against the state, and 10% against the parent. So what you basically have is the parent can only recover $300,000 in that scenario, because it was only the defendant in the lawsuit was only 30% responsible for the situation.
So the empty chair, you cannot recover from an empty chair.
No.
Okay. So do you anticipate that this will be a strategy that that defendants will pursue?
Yes.
Okay. So
Well, yes. So yeah, I do that when I can. So, it's like, yeah, I think this guy over here might have had something to do with it, but I'm not suing him. You can, though, plaintiff. But
it's been, I we talked about this in a recent class. So
yeah,
when I teach my classes, and then I get kind of the real life, what is actually happening. And again, some of my students are school leaders where they've received these lawsuits. So they're living this, right? So they're giving me and everybody else, the what is happening side of this. Now, with that, of course, they're measuring their words, right? I'm saying don't, just because we're in a classroom, don't lay out your counsel's, legal plan. But if there's anything that you want to share, personally, maybe some experiences of how this is impacting you as a school leader, and or things that have been made public, through the media or other things that would be out there. Sure, like that's okay. Um, but yeah, this is interesting because they don't bring this up, and I'm the first one usually to bring up this since we talked. Right, I didn't know this either about the empty chair of the third party, and to me, it's substantial because if I was asked to be an expert witness, anybody listening, I'm not probably going to accept this, but I would immediately go to the counties because that was the clear path last year in our state of the 72 counties to give and they did for a while, and then
well, we
also
had
our
a very
department.
different situation here in Texas.
So yeah, state by state, and the fact that one of our counties turned over basically the keys to the system to a school administrator, saying, "Hey, if you want to contact trace and contact people, here's how we do it at a county level. Just log in with this." And I'm like, "Oh my goodness!" Like I'm not sure. One, I would do this if I were you, but two, like I also get it because if you're not doing it, who is doing it? But so there's some weird responsibility there of this superintendent of the small district taking on this contact tracing through a system that he's not really authorized to have access to. But let's get into this question. So, how might a school district convince the fact finder, who is a judge or a jury, if I'm correct on that, a fact finder, that it practiced due diligence and was informed when it made decisions on how to mitigate the effects of COVID-19 in the school setting? So, how might the school say, we got information that we felt was credible, was current. We put into place practices that we thought were best practices. Like nobody's been through this before. There isn't a standard for this. We didn't train for this in college, and So we think we did steps that were appropriate to mitigate COVID-19, even though the parent is suing and saying my child contracted COVID at school, you didn't do enough. Um, so what could be a school's argument that they put together saying we did the best we could? Like we thought we did a pretty good job.
So I'm going to put some parameters on your scenario there. So we're going to go with the parents are suing for negligence, and there are the parent, the plaintiff, has to show that there was that the defendant, the school district superintendent, whoever, had a duty. Um, they had to um, they have to show that there was a breach of that duty, and then they have to show that the breach was the proximate cause of the injury.
Okay.
Proximate cause is kind of like you can kind of think of it as like the straw that broke the camel's back. Like it's the last thing to happen to make that injury happen. So, and the plaintiff has to show that by a preponderance of the evidence. So that's just like a little more likely than not. It's a very low standard. It's nothing like the criminal side. Beyond a reasonable doubt is a very high standard. So the plaintiff they have the responsibility and the burden to show all of those things.
Okay.
The school district can sit there and not put on a case at all. And
Really? Okay.
yeah, if the plaintiff doesn't support their case adequately, then you can actually move for a directed verdict after the plaintiff's case is over. So that's one thing that can happen.
So Lisa, that would look like a parent saying school didn't do enough in their legal counsel, but they can't say what the school actually did, right? Or what would that look like? Where it's so weak of an argument, the defense could just say, "Can we just this doesn't make sense? Like, can we just like end it now?" I mean, what would that?
So, and this is so like with a negligence claim, you have to show proximate cause. So that child, if you think about that child going to school, maybe being exposed there, but say this child is also in a household with one parent. If that parent is not isolating, let's say that parent is going to work, then the parent has exposure. How do you know where the virus came from?
Right.
So that's where the proximate cause argument can fall apart, and it's a required element. So that's how you can get to a directed verdict. So, but to expand on that, let's say the plaintiff has a pretty good, has put on a pretty good and convincing case. The school district would probably put on evidence of what advice did they review? Where was the source of that advice? What data did they review? When was this discussed by the school board? When was this on the agenda? Was it presented in a public session? Was there public feedback on it?
Okay.
So those are some of the ways that they would show that they were doing what was reasonable. So because the duty that the school board and the superintendent have, has to be reasonable. It can't, there is no way to keep every single kid
Right.
from getting
Right.
a virus.
There's something called assume some harm, right? I mean, like if you were to drive a car, right? Your
Assumption of risk.
assumption of risk, right? There's some assumption of risk that, yeah, if you're in a facility and interacting with other students, and even though whatever measures and HVAC systems and things that, right?
Right.
Okay. Okay. So it's called directive verdict, where the fact finder, which would be the judge, could say, um, just make,
The judge, it could not go to a jury. A
okay.
directive verdict doesn't go to a jury. It goes to the judge because it would be a judgment as a matter of law instead of a judgment based on the weight of facts. So,
Okay. Gotcha. No, I gotcha. So that's good.
no, I was laughing at the comment that you just posted from Bull Rush. It's like,
Oh,
yeah.
yes. It's a rowdy audience on the side. So it's kind of so in my, as an aside, in my book, which is coming out of Law Student Information, I was talking with my publisher, and we're kind of talking about how to market it. And my publisher is like, like 30% of the people who follow you are like survivalists and preppers. And I'm like, yeah, there's an awesome audience, right? So we have to. And then you have Bull Rush, who's kind of like both, and then just like he's edgy. He lives near Houston, by the way. This is a fact.
Okay.
Because he does have a signed bottle from Joe, and he sent me a picture of it. So he went and got a bottle of whiskey from Joe and had him sign it. So yeah, you'll know Bull Rush because he has a cedar fence around his property that he put up himself in the greater Houston area. So he's very proud of it. And he has a lot of insurance on it. So I don't know what that means, and several cameras and things like that, but a cedar fence. It's very high value property.
Insurance.
So this whole concept of tort, what does tort mean? Like a lot of people are like, okay, tort law, but what is tort? We only hear about civil law, case law. What does tort mean? T-O-R-T. What does that basically mean?
So a tort is it's a legal harm that is not derived from a contract. Is that's sort of like the first layer of the definition.
Okay.
Torts can be defined by common law, which will generally extend back several hundred years to England, and they've just developed by tradition and through case law. So, like the tort of negligence doesn't vary from state to state. There can be different types of negligence, but everybody's got a general negligence cause of action. And basically the only thing that differs is you'll have individual states with case law that defines the tort of negligence, but it's all the same definition, like all over the place. The three things that I told you are, that's it.
Okay, and we'll get to those
But
three.
you can have torts that are created by state law. The one here in Texas is called the Texas Tort. I can't remember. I think it's TTCA is the acronym. I can't remember what the C is. But anyway, it allows a person to sue a governmental entity for negligence. Like it'll allow a person to sue a police department for fault in a car accident.
Okay.
So, but generally torts either result in physical harm or they result in harm to like your reputation. So slander and libel are also torts.
For those of you watching at home, my mic is above my keyboard, so it takes away my sight of keyboard. And you're like, Dave, that shouldn't be a problem. It shouldn't, right? But in high school, in Miss Ream's typing class, I always looked down at the keys when I typed. So it's kind of just the way that things are for me. So there's no need to contact me. I am okay, even though if I'm not spelling all right, I am coherent and I'm doing fine. So, Lisa, foreseeability. So, thank you for defining tort. So we're not talking criminal activity right here. What is foreseeability? This word has come up a lot. My interpretation of it, and then you can say, Dave, it's interesting. It's not accurate, but it's interesting. Foreseeability means. So here's an example I use in Wisconsin with my aspiring superintendents. And foreseeability example would be, all right, we're starting to get reports on our phone, on the news and whatever, that tomorrow it's going to sleet. So it's going to be freezing rain tomorrow. So you would expect then in their school tomorrow that the school district would be monitoring this, and perhaps they're monitoring then the walkways outside of the school. They would get out and sand and salt and do whatever they needed to make the walkways safe, or else put up slippery notices,
Those little
signs
yellow
or whatever
cones.
is slippery when wet, whatever. So yeah, they would do something. And if they don't do that, it would be called that they were negligent with foreseeability. And so I think my definition here is that so they should be able to foresee the harm, right? They have plenty of notice. It's in Wisconsin. They should know that the sidewalk is going to ice over. There's these sleet warnings. So could a parent look at this and say, listen, school district, foreseeability, every night on the news, David Muir, ABC News, every headline in the newspaper for the last year, foreseeability, if you're not wearing a mask in a school, if you're not doing whatever processes to sanitize high contact areas, but probably more so wearing a mask, you're more likely to contract COVID. So knowing that, like, you should have taken these measures, meaning you should have passed school policy or at least a school ordinance saying people have to wear masks. Foreseeability. Is this a part of litigation you think could come into play here, of saying you just should have known better, right? Like this shouldn't be a surprise to you that if you don't have masks in schools, kids and staff are going to catch COVID at higher levels than masked schools, I guess. And I haven't seen those comparisons anywhere, but just.
So foreseeability is a big part of the negligence tort.
Okay.
And while you don't have to, defendant doesn't have to be able to foresee the exact mechanism or timing of an injury that occurred as a result of the breach of a duty. Foreseeability is like, it's not every possible outcome, but what are some likely outcomes that have a fair chance of happening? That's basically what foreseeability is. And if the harm, the injury that happens, if like right before somebody breaches their duty, if the harm was foreseeable, was something that you would think in your cost benefit analysis of
Yep.
are we going to require masks, that okay, we have a potential that kids are going to get COVID, but maybe that's weighed against the statistical severity that kids generally get COVID. But of course, that, we found out that changes with mutations and whatnot. Um, but it's based on at the time of the breach. So, does that make
So
any
at the
sense?
time of the breach. So let's say a parent files a lawsuit and says my child contracted COVID on September 25th. So that's the time when school had been in session for 3 weeks. Does that, how does foreseeability play into that? And maybe the plaintiff's attorney, the parent's attorney, saying, you had all summer to prepare for this, school district. You and this again is a school district that didn't have a mask mandate. Would that potentially be like a strong point for a parent and their attorney of saying, come on, like this shouldn't be a surprise for you, right? Like you had
Right. I
time
mean,
to get people trained.
let's say that it was September of 2020 when the kid got infected. We knew the pandemic was going on by March of 2020. They had, 5 months, 4.5 months before school started to figure out what the action plan was. So yeah, I mean, it's a decent argument.
Okay.
Um,
Is that one you usually see as an attorney? Do you see the foreseeability argument come forward, or is it, or am I kind of reaching at straws here
oh
because it's
no, you're
me
not.
and I
You're
can
not reaching.
oversell it? Okay.
No, no. In fact, I'm like up to my eyeballs in two cases right now where um, there are several issues regarding negligence, but a couple of them are whether or not someone had a duty. And then, even if that person had a duty, was the injury foreseeable? Um,
Right.
so, yeah, no, it comes up.
Okay. Well,
So, like in um, car accidents, for example,
right.
um, we know that texting and driving is dangerous and it takes your attention away from the road and away from traffic. And
Right.
so if you are not paying attention to the road, then it's foreseeable that you could uh, be in an accident.
Okay.
Now, it doesn't matter if you rear end somebody or if you cross the median, the center line. You don't have to know which way you injure someone.
Okay.
It's a likely outcome that if you're driving and you're texting and not paying attention, it is a likely outcome that an accident will happen and that you may hurt someone
So I
or
think,
worse, kill
to
someone.
me, Lisa, I mean, that's an important point, because this is something that school administrators don't have addressed in their professional development. When they're obtaining their degrees, their professional organizations aren't telling this. Even their legal counsels aren't telling them about, these kind of core concepts like foreseeability. The other part is, let's say again, it is the third week of September. There's this thing called entropy of systems, right? Entropy meaning systems fatigue over time. Think about a vehicle. The longer you have it, the more things kind of go wrong with it, or it rusts, or things like that. And you have to keep doing things to maintain it. The third week in September, you should not have entropy in a system, right? Your school system, your professional development, all of that that's gone into place shouldn't be eroded by the third week of September for that school year. So as a school, you can't, I wouldn't use it, I guess, as a defense, but entropy, you can't claim entropy for a system that you would expect would be still viable and resilient a month in. Meaning, I guess, if you did professional development in the end of August and you were um, doing your cleaning and whatever your mask. And I guess I'm not sure where I'm going with that. This is a part of the show where it starts to wander a little bit. It's like me trying to play soft or volleyball at UW Superior in the summer of 1999, where I put my arms out and one guy says, "Hey, you're walking the elephant," which apparently is when you just kind of like keep your arms out, anticipating someone's going to hit the ball to you. But okay, so foreseeability is negligence. There's three parts of it. Negligence. Let's make those clear for people.
Well, there's three elements of negligence.
Three elements.
They each have little bitty parts, so they have nuances. Foreseeability is one of them.
Okay. And then proximal harm, and what was the third?
Proximate cause.
Proximate cause. Okay.
So somebody has a duty. Somebody breached the duty. The breach of that duty was the proximate cause of the harm.
So it could be a one-on-one aide working with a student. That aide has a duty to wear a mask, does not wear the mask, is positive for COVID. The student contracts COVID. You can make an argument. Proximal cause. This aide was with the student 60% of the student's day, and the student.
And within close proximity.
In close proximity. Okay.
Right.
Got it.
So you don't have, like with proximate, in that situation, where earlier where I described, you've got this kid going to school, they have one parent, where does the exposure come from? You don't have to prove something 100%. So in the example that you just gave, that would be a good way for a plaintiff to build their proximate cause argument, is showing, okay, this student was with this person for 4.5 hours a day for the 2 weeks before he was diagnosed with COVID. We know this teacher wasn't wearing a mask. We know that they were within 6 feet of each other because they work one-on-one, generally at the same desk. Those are all things that will move the needle on proximate cause towards the plaintiff.
Okay. So all things, if you're the plaintiff, if you're the parent in this, that you'd want to know and want to document as you're presenting this argument into the court, right, into the judge. You'd want to have this information.
Right.
Okay. So what implications?
Drink of water.
What?
I need a drink of water.
All right. This is going to get a drink of water. So here's what I'm going to do. I'm going to go here solo, and I'm going to tell you about the greatest book ever written about the $3 billion school safety industry, School of Errors, Rethinking School Safety in America. This book comes out. It's in hard copy. You can get it now from places that sell books, right? $30 hard copy. I wrote this. It came out in 2019, but this is a phenomenal book. Gives you the inside workings of what happens for school safety decisions and why you need to question your school board and your school districts when they're making $1 million decisions on putting bollards and cameras and things like that in front of buying committees and saying, yeah, we're going to do this. We're going to put bollards in. Doesn't make sense. School of Errors, Rethinking School Safety in America. And if you read it, please leave a review. We're up to 43 reviews. I'm hoping we get to 50 by the time the velocity of information comes out. Lisa's back, substantially hydrated right now. So we are going to get into our last few questions here. But so Lisa, what implications? Let's talk about board meetings. So what if a board hasn't properly posted their meeting, right? They have to post it so many hours, days in advance, their agenda, what they're going to talk about in open session, closed session, or if they don't conduct their meeting in proper ways, again, which have happened in Wisconsin. People have contacted me, or administrators have said, Dave, like, here's a link to our board meeting, which is recorded online live stream. And I don't think this was conducted by proper. So Robert's Rules of Orders is like, first motion, second motion, and things like that. And one of the things too is there's been a lot of turnover on school boards. People during the time of COVID have said, I've been harassed as a school board member because I vote one way or another. And one school board member said people came to my house and dumped garbage at the end of my driveway and things like this. And sort of like, I'm not running again. So you have a lot of new people on school boards. Um, and so these mechanisms of school boards run kind of clunky because people don't necessarily know how to conduct a meeting. So what happens in all of this if a parent or can come back and say, hey, this meeting wasn't properly noticed? Like the school board talked about mask at the meeting, but on the agenda it only said like COVID discussions. It didn't say like mask mandate or anything like that. Or they ended the meeting improperly, or they didn't give time for input from the audience or something like that. How can that, I guess, impact litigation like this? Or is it substantial, or is it like that's kind of secondary? Or what could be like a really big mistake that could happen out of a improperly conducted meeting that could impact this?
So I'm going to use my lawyer answer.
Okay.
It depends. So in the several examples that you gave, you're going to have to weigh, okay, how much harm did that really do? Like, if you ended a meeting improperly, did that really have an impact on the mask mandate? Probably not. But something like not allowing for public feedback
Right.
on that would potentially be not viewed favorably by the jury. So it just kind of depends. So like ending a meeting improperly isn't going to have a big effect, but not properly noticing your meetings, that's a problem. So
So what's happened? So what's happened, Lisa, is some school boards haven't properly noticed this. And if you really dig down deep into it, like you won't get this on public record, but you can kind of assume that it's because they don't want a contentious audience, right? They don't want people being vocal with them, and so they're trying to eliminate that because it's become very uncomfortable for a position that you might be making $3,000 a year for. Um, and this is also one of the on September 29th, the National Association of School Boards sent a letter to Attorney General Mary Garland saying, help us out. Like school board meetings are becoming out of control. AG Garland on October 4th sent a letter to the FBI saying, in 30 days, I want you to come up with a plan for how school boards can more safely conduct meetings where people aren't harassed, school board members and things like that. So some of these things aren't being properly noticed. And so I guess as you've said, right, if you end a meeting kind of clunky and it's not per Robert's Rules of Orders, that's not as big necessarily as if you put out an agenda and the agenda doesn't indicate that you're going to make a decision during the open session of the meeting on mask or no mask. Would that be correct?
what? I'm
Okay.
sorry, I was responding to Mr. Bacon.
Okay. Oh, Bacon will do. So I think if you're a district and your purpose, I guess there you'd have to say, as a plaintiff, as a parent, I would say you're purposely having a meeting where you're not doing this in public discussion with mask and no mask. Like it's not on your agenda. Like that is a mistake.
Right.
Like it
That's
seems like you're trying to limit input from your
Yeah, that would definitely be problematic, especially because school boards are generally subject to some sort of open meetings provision, some sort of transparency provision, anything where you are not giving notice, you're not giving opportunity for constituents to shape policy. It's not a good look in litigation.
right.
So, and yeah, Having angry parents or angry citizens in your school board meeting is hard. That's part of the job.
And that's the part which has become complicated. And this is actually kind of after the fact with the October 4th memo from Attorney General, Merrick Garland to the FBI saying, and actually in the memo, and I had this in a previous podcast, maybe a week or two ago, in the memo, he states to the FBI, in 30 days, which would be beyond November 4th, you need to advise districts on how they will obtain and preserve evidence of threatening behavior, which basically I interpreted as, and I talked with my superintendents about this, and I say, basically what they're telling you is record your school board meetings, like record the people in the audience, like have them come up and say their name and address and record everything that they do and all this stuff. I said, which I'm not sure is the look you want to go for, but this is kind of where we're at.
Well, I mean, I think that recording those meetings, including the public comment, that's transparency. So I think that having someone state their address there's a good argument there for invasion of privacy, but having them state their name, I don't see a problem with that.
So yeah,
it gives more visibility as to what is happening in those meetings. We have here in Houston, we have city council meetings that are live streamed and recorded, and that's exactly what's going on. You sign up for public comment, and
right.
Your name is on the list, and when you get called, you say your 2 minutes, and that becomes part of the record. That should also be part of that public comment should also be part of the meeting minutes. And you can't just have
okay, that's good.
This mass yelling going on. It's got to be something organized. So getting people on creating a list of people to testify, if that's in your bylaws, that's a really good way to do it. Explaining at the beginning of the meeting, you're setting expectations at the beginning of the meeting. We are obligated to take minutes. So when it is your turn to speak, we'll ask you to state and spell your name for our secretary or parliamentarian. And, then we'll ask you to, state your opinion or make your argument or ask your question.
So you mentioned that the public comment should be part of the minutes. And I know a lot of districts that don't do that. They'll just say this person presented, but then whatever they presented isn't documented. So that's a good point. And that's something I've been sharing with my superintendents, is to say, and one of the superintendents said that his administrative assistant who attends the meetings just said, well, we've never done it this way, and it's a lot of time to record that and put it into the minutes. And I said, well, but that's the only evidence you have, right? That's your board minutes of what happened when this person presented. You just don't put, this person presented and during the public comment section. I mean, right. It just doesn't cut it. Okay, so that is really yeah, that's interesting. So one of the things I've interpreted from the change now of districts saying state your name and your address is, if people state their address, they have to fear that they'll be doxxed. And right. Then, and that's happened. Like I know situations close to me within 20 miles of where I live where that's happened. Someone now has said that, and then people go to their house. So that becomes a deterrent. And so it's tricky, right? What if the school board's attorney says, okay, people, whenever they present now, you can tell them to identify themselves and identify where they live, because you want to have them identify that they live in the district, I guess. Is that a practice you would see as legitimate or a practice that could be challenged? Or what if someone said, no, I'm not going, I'll give you my name, but I'm not going to tell you where I live. And, during a recorded meeting.
I don't know the intricacies of that.
Okay.
But like I could, without getting into privacy concerns, I would think that somebody uh, at least signing an affidavit stating that they do live within the district before they get up to testify.
Okay.
I don't see a problem with that. And with an affidavit, they're going to have to show their identification unless the notary personally knows them.
Okay.
So,
So, so I would see that as a step that should happen before they come up to the microphone.
yeah.
That they shouldn't have to. Okay. And
Well, and
that's
like with the Houston City Council, they allow for sign up like days in advance of the meeting. So,
okay.
but yeah, I mean,
So,
I think there is a good point that yeah, it should be somebody who is a constituent in the district, unless it's someone who is being invited to provide comment on something. Like if you had um, an infectious disease specialist coming to talk by
right.
invitation of the board, then no, you don't necessarily have this is it's akin to having an expert witness. No, you don't have to find a disease specialist who lives within the school district. But the people
So,
who go to school board meetings that aren't their own, that
yeah.
that's somebody with way too much time on their hands. And I mean, I can understand that politically why that would be important to someone, but
So this is interesting because we've kind of seen this, I guess, what I would call stacking the deck, or people coming into board meetings who don't live in those areas but do have an interest in the topic. So, and then they can come off of saying, "Listen, I am considering purchasing property here," something like that. So they try to give a validation for why they're giving input into this meeting. But okay,
yeah, they wouldn't have. I don't think that they would have to be allowed to give public comment. So they could certainly walk in and sit and be in the meeting, but I don't think there's any obligation to give them the floor.
so, Lisa, what is a freedom of information request? And like, so let's say a parent was to get this from a school, freedom of information request. Um, I guess what is that? What might be something a parent would request from a school
So,
or a newspaper, for example?
oh, sure, it's mostly used by journalists, um, and the Freedom of Information Act it's a federal law that protects it, basically protects freedom of the press, and that and gives a check on governmental entities so that there is transparency and the press can report on it. But that's not the only thing that it's used for. Within the states, each state generally has their own law that also imposes that sort of transparency onto state, municipal, county, um, governmental agencies and entities. So, a parent in this situation might ask for something like the agendas from the school board meetings since, you know, pardon me, since January of 2020.
Okay.
Um, so that's one way they could get the information. But once this suit has been filed and served, they're going to have another avenue to get the information, and that's through discovery. But there are and you know this from being a school administrator, there's lots of data that's available to the public, and there's lots of data that's private because it involves individual students. So they, wouldn't be able to get like how many, they wouldn't be able to get how many times was, Mary Smith or Joe Jones written up for not wearing a mask.
Okay.
But they might be able to get how many total write-ups have there been in between September 1 and October 15th of 2021
Sure.
without having
Sure.
any sort of individual data on it
So yeah,
or
so
identifying data.
they can't get down to the kind of the individual level, but they could get into like how many times have you infractions or and there could be freedom of information requests. Would that so let's say that a district did professional development on COVID prevention to their staff. Would that be something that could be obtained through freedom of information?
Quite likely.
Okay.
Anything like the scheduling requests and the emails that were sent out to the staff and teachers
Okay.
about the
Yeah.
before the meeting, things like um, PowerPoint presentations or handouts that were given during the meeting, things like that would probably be available.
Okay. So what I'm seeing right now in Wisconsin, Lisa, and I've shared this with my superintendents. We've gone through case studies like newspaper articles, but some districts are saying, okay, one, they're either not responding to a freedom of information request, they're just ignoring it. Remember, the old da, 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 it's not happening, like we're ignoring it, like eventually you'll go away. And so that's been happening. And the second is, okay, we will respond to this. We'll help, we'll provide this to you, but it'll cost you $27,000. And the person's like, what? Like, I can't afford that. That's crazy. That's insane. Um, so there are these two aspects which are happening. And then um, there's this thing called the Wisconsin Transparency Project. So it's a small legal team in Wisconsin. They exclusively center on helping to make sure that the open records and meetings laws are enforced. But like that's it, right? There's really nobody else on the side of that. So what's happening is one is districts simply don't respond. Not only districts, but like government entities, the county health department, stuff like that. We're not responding to you, and there's really nothing you can do about it. You can appeal it, but nothing's going to happen.
Well,
And
I mean, they can likely sue on it
they could
in
okay.
order to uh, compel the release. Um, but that takes money.
So it takes right, and even the Wisconsin Transparency Project, for example, isn't free. Like you have some costs you'd have to incur to get some assistance there. So I'm seeing this. I'm seeing this as a very routine practice now. Something I didn't see in 20 years. In the last 20 years, I'm seeing now in the last 2 years, is districts responding of saying, yes, like, but for us to do this, it'll cost this huge amount of money. Let's say $20,000. Let's say a parent is trying to say how many staff and students were out because of COVID, just a number, right? So you're not getting into group data, or you're not trying to identify students by age level or disability or anything like that. And a district responds $20,000. So what's the deal with that? Like, because I'm aware that a district can say we have to have a person who's trained in confidentiality in our tech system and the integrity of it, and they have to go through and they have to redact information and stuff like that. But I'm seeing this clearly as a barrier. And do you see this in your work? And then also, like, how might you navigate if this is the response, which most people will probably give up at, of saying, okay, like here's a $20,000 bill for us to maybe give you information which will be helpful. And the person's like, Well, that's crazy, right? Like, how do you work around when this is not? I guess it's become a legal tactic. I would say I've seen it enough now to become identified as a legal tactic by the school district to say, well, we'll hit them up with a high freedom of information request fee.
So the way that states can avoid this is by putting limitations on what the governmental entity can charge for certain types of data. Maybe it's you charge 10 cents per page if you're printing it out on paper, or for every gigabyte of data, it's X amount of dollars. So those are some ways to combat that. I think that people who are making this request they've got a pretty good justification for either suing under the statute, or there could be a process of going to the Attorney General's office to complain about the invoice.
Right.
So yeah, so there may be another avenue besides suing under the open record statute, in whichever
You were
state.
saying something, Lisa, previously when we talked about something like asking, is it gigabytes or terabytes, or trying to narrow your request down, at least to make it um, on face validity seem reasonable if it was examined by a third party.
Right, right. Um, so, in the example that you gave, that asking how many days, you know, faculty, staff, and students were out because of COVID. So, the district, one thing I wanted to point out was, the district may not be tracking the exact reason of why somebody was absent. It may be, as far as faculty and staff goes, it may be, okay, were you using sick leave or PTO? And, that's the extent of it. And for the kids, it would be, was this an excused or an unexcused absence?
Right.
And so that specific data may not be something they're tracking. And the school district would have no obligation to create that kind of data, you know, barring some, mandate that came from the county or the state.
Right. So if they're saying how many kids were out with COVID or something, and you're not required to track that or report that, you could be like, we don't have to try to aggregate that information because it's not required that we report that anywhere, and it's not something we document in our systems.
Right. But if they did document, they needed to cough it up.
They need to cough it up.
So
as we get into the ninth inning here of this, which has been awesome, and thank you so much for everybody over in the comments. Old Humble Distilling Company has been vibrant in the comments. Moose's Gal's Corner, John Steele from Seattle, and our friend Bacon from Inglewood, and Mictibus from Mictibus Land, which is a sovereign country, by the way. It has a weird tax structure, though. So John Steele, yes, John Steele. No laws protect us from people who have not respect for the laws, or no respect. Your right against unwarranted search doesn't actually stop a cop from illegally searching your car. That's from Joe at Old Humble. So yes, that's why I only ride a horse. Gave up on a car about 4 years ago. So we'll see how it applies. I don't know. Probably the same thing. I probably didn't get myself ahead in this, but so
Andrew S. is asking the really hard-hitting questions.
This is participating in an online class tonight. We'll need to come back. So yeah. Mictibus is picking up a side degree in martial arts, but it's online. So the thing is, I'm not against online instruction. I just don't know how well it transfers into like a martial arts. He's up to a blue belt. right now, just an online instruction or destruction. He's taken out a lot of things in his house, including a ceiling to floor lamp that was in his living room. So with a sidekick. But yeah, I don't know. I mean, some of these things I think have to be authentic, but
I mean,
I
who's
guess maybe
willing
I'm
to
just
hold the boards that he had a break? I mean, who wants to do that?
right. Yes, he has a workbench with a yeah, some kind of vice apparatus on that.
Okay, okay.
I don't know. I just again, I mean, there's some part of the authentic experience which I think needs to be there, but he's a hard worker, so I'm not trying to bring down what he's doing. It's kind of innovative. I'm just saying before you put that into practice, I probably would try to do some authentic application with your martial arts degree. So all right. Oh wait, he just messaged me. He says it's not martial, it's martial artists who paint pictures. So that's a different angle on it right there. So he's actually like a martial artist who's making paintings. So I guess you don't have to be violent in that regard. Well, that's cool.
So, are you using like karate chops to paint a picture with your face?
It's so new to me, Lisa. I don't know. This is yeah. I have to find out after the show what is going on.
Yeah, I'm really curious.
Martial artist paints picture. It's a
So
headline in his
I'm trying
newspaper.
to imagine Bob Ross like in his.
A much more angry, yes,
Now
motivated
he
Bob Ross.
did beat the devil out of his brushes when he cleaned them. So
Wow. Yeah. My youngest daughter, by the way, created a diorama of an 1800s village, which included modern military figures that she glued onto the board, and then also included a very wide road, which proportional to the houses was about a 75-foot wide road, which would have gone through town, which made it very hard to then kind of arrange the houses in a sensible manner of trying to. I said, you have to come up with a side story here of why this was such a poor example of city planning back in the 1800s. This was the one town where they initially put the road in first before they did anything else, and then they just decided to just build substantially far away from this road, which still the houses seem to come up remarkably close to this road. A good learning process. So she actually said we have to have some form of government in this image. So that's where the soldiers came out. And I said, well, you could have had a post office too. It was too late. At that point, yeah, we were full Paul Revere and War of 1812 going on. So, okay, parents, we get down to this lawsuit. Parents suing a school district. Hey, you didn't keep my kids safe from COVID. What's their strongest argument?
I think it's a policy argument is arguing that the district should have had a reasonable policy and should have been enforcing it. And wherever the breakdown was there, that's probably going to be their strongest point. I think their weakest point is the proximate cause.
Okay.
And unless you have a situation where you can explain that this student had close contact with this person for this amount of time. Granted, we know with COVID that's within 6 feet for about 15 minutes.
Right.
So it's not that long, but the more time, the more exposure to one person or to school personnel or to fellow students in some way, that builds that proximate cause prong. But the defendant school district can come back and say, look, we know that your child also participated in gymnastics or in
right.
chess club, or has um, other siblings who he's in close proximity with that have been out in the world, and again, for parents or extended family or anybody else who's living in the home. So there are certainly ways to tear down that prong of the argument. The defendant only has to show that the plaintiff didn't meet their burden on one element. So
Of
whereas
the
the plaintiff
negligence.
has to show that they
Okay.
do meet their burden on all of the elements.
Of the 3 with negligence. That's
Right.
what you're saying. Okay. Okay. Right. And so, okay. So I think you kind of framed it then. If you're the school district, how do you prevail in this lawsuit?
Where'd you go? Like I said, I think that the proximate cause prong is the strongest point for the defendant. I also think that um, the reasonableness of imposing a duty on it, like the duty that's imposed has to be reasonable. You can't have a school district be responsible for preventing everyone in the school district from getting COVID, or everybody that walks through their doors from getting COVID.
Right.
So I think that the more that a school district can show that the um, the policy was carefully crafted, uh, show the process that they went through in order to arrive at the policy, the process that they went through to educate faculty and staff about how to enforce the policy, and then showing as much evidence as they can to show that it actually was enforced, and that they did what was reasonable.
Right.
It wasn't everything that they could have done, but that's not the standard.
Because I think you were telling me, yeah, it's reasonable. And if they were saying, hey, like we were listening to the FDA, the National Institute of Health, the World Health Organization, our local hospital, and we were getting guidance from these areas, and it shows the due diligence and that they were trying to inform themselves. Um, so here was something I thought was really fascinating when you were sharing this with me in a previous discussion, and you're saying, a school district could also look at their financial records and bring those up as evidence. And for example, say, listen, we've spent 3 times as much this year on hand sanitizers, soap, disinfectants than we spent in the last year and the year before that and the year before that. So our financial records can show these expenditures, which indicate, we have done mitigation efforts. And I
Mhm.
thought that was fascinating. I never thought about that before. Is there anything else where there might be this hidden data which might support a school district that is something where people probably wouldn't look initially?
I think, thinking back to when I was a kid, I remember going to a school assembly, and they talked about dental health. They talked about brushing and flossing your teeth. And when we went back to class, we each got a tablet to chew. And
Yes.
when you got finished chewing the tablet, you could see where you had missed brushing, and then they give you a toothbrush and toothpaste, and you know, you'd go brush all that off your teeth. I think similarly, you're gonna find uh, you're gonna find curricula for the training you did for the teachers, and also curricula for the students. You're teaching them, this is why we're wearing masks. This is why we're using hand sanitizer. Um, this is this is why we're not doing, such and such activity, is because of this virus, and at an age appropriate level, you know, teaching them about a virus and how it's transmitted. Um, so I think you could also look to those programs and materials to show that we were doing more than just a mask mandate. Um,
Sure.
so, but
See,
yeah,
that was fascinating to me of looking to the financial side. I didn't think about that at all. And you also said, there are these obscure pieces of evidence, right? Like if a teacher writes on a calendar
oh
that,
yeah,
hey, we're supposed to have a staff meeting about, COVID mitigation on this date. And even if it was something where there wasn't a formal handout by the administrator or whatever, that can be a piece of evidence. And when you get into discovery, there can be a lot of things that show up that necessarily aren't in the formal, um, whether it be agendas sent out or emails or things like this. It can be notes people took, things people jotted on calendars and things like that. So I thought that was pretty interesting.
right.
Um,
And the context that we were talking about that in was, how do you, if for some reason, your PowerPoint that you presented that day had been, the file had been corrupted or something. How else could you go and get that data?
right,
Now, in discovery, you're not going to go and ask all of your teachers for copies of their calendars. Um, but if you do have a gap somewhere, there are some other places to look to be able to, corroborate that evidence. Um, because also, I mean, there's a concept in discovery about how much discovery is enough, and is the cost of that discovery justified, um, by the value of the suit. So you have to, and whether that's monetary or equitable value, um, does that is that impactful enough to justify X number of thousands or millions
right.
of dollars for discovery?
Or
So,
pulling, yeah, all of the teachers from their classrooms for X number of hours to give testimony and things like
right,
that. And how disruptive would that be to the school function? And
right. I
how
mean,
much would that add to the. So I have one last question. So, as an attorney, what are your own best practices? And especially an attorney who specializes in kind of that forensic side of having things ready to go. What are your best practices for advising someone, hey, here's how to be comprehensive and here's how to be prepared in case litigation knocks at your door? Like, what are some things people can do to be in a better position if that happens to them?
so I think what is a good business practice or a good personal practice for keeping your life organized, those are always going to be good practices when it comes to litigation. So, uh, there are things like, um, if you've got all of your tax returns and individual files, if on if we're talking about a school district, if their data is organized and has like consistent naming conventions for files, like it's the 2021-10-04
Right.
agenda, um, rather than just being, you know, agenda or October agenda or October 2021 agenda. There are ways to make it, you know, easier to have that information organized so that, if they do get involved in litigation, you're not scrambling to find it and you're not sifting through a bunch of stuff that isn't relevant in order to get to the things that you do need to produce because somebody knows that they exist. I mean,
Right.
so the more organized uh, they can be, the better.
I
So
think that point really resonates too because there's a lot of turnover in schools between administrators and then also board members and who is the person assigned as the secretary to maintain board minutes, but also a school who's assigned to maintain records of professional development and things like this. So they kind of get lost. So as you've said, identify things in kind of that metadata, like the exact day and the exact heading of what was the presentation, or a scan of it, or a copy of it, or to keep it and timestamp it is absolutely essential.
and
So
there's so much we can do now with digital data. Oftentimes something is automatically timestamped when it's created and automatically timestamped again the last time that it's modified. Um, it's sorry, one of my cats was talking, and it's my feral one
okay,
or he's my scary cat. It's about time for him to come out and
gotcha.
work and talk. Um, but what were we talking about? Oh
Like
yeah, like
how
how
they can best prepare for this.
it is, and it's so easy, but it takes work to develop the system, and then it takes a commitment from everybody who has access to the system to follow those rules, to follow, how the way that files need to be named and the way that folders get set up and what goes into those folders. And
Right.
so, um,
All things that will help you during discovery or evidence or all of that, right? Taking that extra moment to do that.
right. But it's also a good way to, you talk about turnover, it's also a good way to build institutional knowledge.
Yes.
So when you have a new principal come in and they're trying to get their feet on the ground and get oriented, these are resources that they can easily go to and say, okay, they can do a search of the agendas and see, okay, when did we talk about the athletics budget?
I like it.
So,
Yeah. And that's a point where it's good to underscore that because with turnover, that's not consistently happening. So we have a question here, and that was the last of our questions for the show and our discussion. We have a question here from Moose Gal's Corner. She's saying, Lisa, since there are vaccine requirements for students to attend schools, is that only for public? Like, for example, like California, we've seen there's a vaccine requirement. Is there anything legally stopping school districts from requiring all students to get vaccines? It's from our friend here, Moose Gal's Corner in Illinois.
yeah, no. Um, the case law is pretty well established that vaccines can be required. Um, there are generally some like religious objections that can be raised, and again, those are discussed in case law, but it typically has to be a pretty well established um, objection. So, for example, um, uh, Jehovah's Witnesses don't accept blood transfusions.
Okay.
So that would be, and that comes from high up in the organization, like that's a well documented objection. So that type of thing um, would likely have to be accommodated. Right now, as far as the COVID vaccine goes, there's been no major governing body of any denomination that has come out and said, we object for X reason.
Right.
So, but yeah, with there's a public health and safety um, line of case law, and vaccinations are in it. So, and then with, Muscal brought up the public versus private. A private school has even more leeway on that. Like they can absolutely that. I think they can absolutely require a vaccine and say,
Okay.
"You don't want to get vaccinated? Here's your tuition back."
Goodbye.
Yeah.
Okay. Wow. Good. Well, let's wrap it up. And this has been phenomenal. I just want to thank you, Lisa, also for so much knowledge you've given me to clarify kind of where I was at with trying to frame this for students in my legal issue courses, and thought that this would be a very relevant podcast because it's making the news daily where I'm at. School district is suing or being sued by a parent, or else a school district is having a meeting to change their policy because of something that's happened, COVID related, illness or death of a student, for example. And just to let people know kind of what does that look like from a parent perspective, from a school perspective, and this whole thing of a empty chair, how liability could be assumed or assigned fault, I guess, into those areas. And then just best practices, right? And making decisions, how to inform those decisions, how to document those decisions. And as a school administrator, what I'll bring into this discussion is, it's 1 to 2 years for a superintendent for their duration in a school district. There's a high turnover rate. Principals, 2 to 3 years. Staff are turning over at higher rates also. We know students are moving district to district at the highest rate ever in history. So it's transient
There's a lot
population.
of mobility.
Mobility, right. So to try to get reliability on this is difficult. So as districts are working through this, we can't assume anymore that, kind of, as you said, this institutional or legacy knowledge of these people being in a district for 10 to 15 years and can pass this on. That's just not there
Right.
anymore. So how do districts then maybe try to infuse that into their documentation or offload that into their documentation and their procedures or policies and things like that? So I'm going through any questions. Here's one from the Bacon. He says, Lisa, any counter argument of schools requiring vaccination from polio, MMR, and other diseases? So,
I mean, really, the only counter argument that's viable right now is a religious objection.
okay.
So,
And then here's our good friend at Old Humble Distilling Company, Bacon. That's always one of the reasons why it's so damn mind-boggling. Or that's where Bacon was saying it's homeschooling. As a school administrator, Lisa, it was perplexing for me for a number of years because we had maybe a 90% compliance rate with vaccinations.
mhm.
And so 10% of students, and you wouldn't push it, right? The state would tell you not to push it, just have them in school, have the students. And now that's changed significantly too. So it's also this just change in emphasis from the state. That's where this whole third party thing gets interesting to me, because as a school administrator, I would be able to testify and say, when we had to submit our mumps, measles, diphtheria, all of that the state was pretty much satisfied with 90% or 85%, and they wouldn't bug you after that. Like, it just kept being the sliding scale. And it was this kind of mixed message from the state that it didn't matter. We just wanted the kids in schools. And yet, like, that's not the case necessarily with COVID. Wisconsin doesn't have a mandatory vaccine for students, but I know that other states do. So this has been awesome, Lisa. I know you have other things to do. You have a few bags of candy you're going to try to give out on November 1st as kind of a pseudo post-Halloween event.
No. Like I probably have maybe 20 pieces of candy left. So
There's 20 happy kids out there, or
there
teens.
are no kids out there.
Just you can throw it, like toss it underhand so it's not damaging.
I'm telling you, there are no kids.
we have some leftover candy. Unfortunately, not much. Unfortunately, it's not the kind that I like. It's like Twix. I'm like, ooh, like those go
What?
out first. I'm not a big fan of Twix.
I love Twix.
Ooh. I'm kind of
Yeah.
Nestle Crunch Bar, like 1,000 grand, and I'm like, wow, like those got to be held back. Those are the last things we
I've,
give out.
I've got some Nestle Crunch.
Okay, so
Got some
Nestle
Nestle
Crunch,
Crunch, some Baby Ruth, and Butterfinger.
yeah, Baby Ruth, all high value candies.
I did
So
good. But yeah, like I said last night, I made one of those kids give back a Twix. I was like, just
whoa,
paper
awesome.
moment. I was like, hey, come on.
Give it back. So, everybody, this is your good friend, Dr. David Proden, here at the Safety Doc Podcast. And today we have been fortunate to have our guest attorney, Lisa Linney, and she's with Murphy Legal in Texas. So you can, you'll probably be Googling it tonight. You're like, Lisa, I need you to help me out. And,
I'm
so
not
this
sure
is
I'm on the website yet. I still need to write a bio.
right at bio. Okay. So, yeah. So yeah, this again, it's fascinating in the fact that we don't have case law, or we can't kind of benchmark back to how this was handled in the last pandemic, because we'd have to go back 100 years. So when I'm meeting with school aspiring superintendents or current principals, or even people serving in the superintendent role as their first year, their heads are just like spinning. They don't know where to go with this. Some of them feel abandoned by their county organizations, their state organizations, and they want to make sure that they are making informed decisions. And then you also have this situation where necessarily boards, a school board and a administration, a superintendent, might not agree. So the Board of Education might make a decision that's not in alignment with the superintendent. And if you're a parent, all of this, and you want your child to be safe, and if you're looking at litigation that's coming out towards schools, understanding what that probably means, and then also I would say, as a former school administrator, right, working with school administrators, they are working to keep your kids safe. Everybody wants kids to be safe. They're trying to figure this out. They're trying to figure out, what are our high contact areas? How do we sanitize those? And there's this big question too, right, on what is the efficacy of mask 1 versus mask 2. So here's a mask that a child has, and then a second mask is really like a modified bandana. Like, how do you make those comparable? So there's a lot of things that have to be figured out. But I think we're in this part 2 where it's so new, people just don't have this figured out, and they won't have it figured out for a while. We'll be kind of analyzing this reflectively through forensic lawsuits, which lawsuits, I guess, are forensic in most part. But so, Lisa, anything to add to our discussion tonight, or to our audience?
I've really enjoyed it.
So bye.
The comments have been really active, and like I have not been able to keep up with them at all. So I'm kind of scrolling through here, and like there's some really good discussion going
Yeah.
on.
Yeah.
So
I appreciate all you followers of the Safety Doc Podcast. We were up to 463 subscribers coming into today. So tell a friend, tell a relative, tell a distant relative, say, hey, you have a YouTube channel? Log in and subscribe to the Safety Doc Podcast, because if we get the Safety Doc Podcast up to 1,000, then two things happen. One, the super chats can be monetized, which will allow me to buy more books to get into more libraries. And the second is, it's kind of a credibility thing as we get up to 1,000, as I do more work with people. They're like, hey, do you have 1,000 subscribers? And I'm like, yes. I'm like, combined between that and Podbean and everything, iTunes, yes, I have 1,000. But and so Lisa and I are working on a show in the future. It's more of a legal note. It's called You Can Mail Anything. And it's part of the law dating back to the Constitution. Not sure where it'll go, but alcohol, batteries, fireworks, Yeah, all of those things. Anything can go in the mail. Like that was part of the Constitution. It got edited out at the bottom. So if you look at any printed copy of the Constitution, you can definitely see a scissors mark across the bottom. And and what was below that was all postal service related, and it got cut out at the last minute. So, but just one of those things. Like it just. But yes, if you go and you check out the original Constitution in Washington D.C., right? You can see that down below.
That little perforated dotted line.
Yeah, the perforated and the shears were pretty rough back then, so the cut mark isn't very clean. And you're like, what was below that? That was all postal related. Like, what can you mail and what can't you mail? But yeah, that was one of the things. Could you mail whiskey? And a lot of the founding fathers were like, yes, and some were like, no. So it kind of was undecided. And they're like, well, we've got to put this thing to print. Like, we can't delay it any longer. So they just like, well, let's cut off this. We'll deal with it later. Never got dealt with. So for a later issue, we'll try to figure that out. And we'll bring in Joe, who's kind of taken this on as a pseudo sabbatical scholarly type of work. Study this. It's a little bit eclectic, scattered right now, but it's coming together. So Lisa, thank you so much. I will admit that last night I ate many Twix bars and many.
I thought you didn't like the Twix.
No. Sorry, so you're right. I don't like Twix. 100 grand, right? Or 1,000 grand or grand or whatever it is.
100 grand.
100 grand, and then the Nestle's, and then I realized about 10:30, I'm like, I ate too many of those. That was a mistake. I didn't get sick, but I'm like, oh, that's a mistake. Like I kind of went over the top on that. So, but yes, so I still have a lot of candy, and my youngest daughter is willing to give me candy, and I'm like, no, that's yours. Like, you went out and you got that. I don't need the candy. But she's like, do you want this? I'm like, no. I'm like, I'm good. Could you keep your Skittles? We're all good there. So everybody, I mean, this is a crazy time for kind of litigation. You're going to be seeing, you'll be seeing more of this on the news. You can refer back to this podcast. And Lisa, just thank you so much also for, I enjoy Thursday nights on Old Unbold Distillery podcasts. You have a wonderful sense of humor. It's very much appreciated. And thank you so much for personally giving me some guidance that I've used in my classes on helping, my superintendents on how they frame arguments. It's been extremely helpful. As I said, we had a discussion. I took like 3 pages of notes. So you're really wonderful and generous in those regards. And this has been a terrific show. So thank you so much, Lisa.
I've enjoyed it. So, but yeah, I mean, I'm very informative here, and over on the Old Umble Happy Hour 2.0, I do a segment on the ridiculous things I have found on dating apps. So, don't miss my unhinged chronicles.
True. And that is Thursday nights. What time? Central Time is the Old Unbold Distilling?
Joe, what time? I think it's at 9.
Is it 9?
9
p.m. Central Time. It's funny because I had to ask Lisa, I'm like, what time zone are you in? She's like, I'm in Texas. I'm in the same time zone as you. I'm like, I don't know how these lines break down. And
if you're is in the mountain time zone. So
okay.
I mean, Texas is that big.
And I have a friend who lives in like Arizona, and like, we don't follow time zones. And then like Phil Henry, it's like
they don't do the daylight saving time.
Daylight savings time. So I'm like, I don't know. Like, I have to ask you. I have no time what it is. I have no idea what time it is by you.
So there's no S at the end of saving in daylight saving.
It's just saving time then, right? All right. So yeah, we hit that on November 6th. I believe the evening of November 6th is where the clock falls back. I don't like that personally.
I'm like, stop messing with my clock. Just
I know. Resetting the clock.
The sun come up and set whatever it does. So I'm like, you're right. It's night of the 6th, morning of 7th.
It's this, and my birthday is November 7th, by the way. So
you get an extra hour on your birthday.
I guess I do, but I don't want it to get dark an hour early. Like in Wisconsin, that's a double whammy. You get it cold and snowy, and then it gets dark at 4 o'clock.
Yeah,
So
I remember being in law school in Chicago, and I lived in the dorm, and we'd get out of class and it would get dark at 4 o'clock. And so when I did that, we there was a big group of us that usually ate dinner at 6 o'clock. And once it started getting dark at 4 o'clock, you started noticing everybody's coming down to dinner in their pajamas.
yeah,
Didn't happen in September, you know?
it's this it's this disheartening time. And I'll admit, like the older I get, like I just kind of between November and March in Wisconsin, you just get through it. And then April, snow starts to melt. You can be outside and do things. I'm a big cyclist. Like I will bike 100 miles. Like that's my thing. I'm a long distance cyclist. And, that ends this time of year. You can't. Well, yes, like people say, like you can bike in winter. Yeah, I guess you could. I mean, kind of like Evil Knievel could jump over, a building in Las Vegas. But yeah, no, I'm not going to do that. But so I really miss that. And so like having to this week kind of decommission my bike, and do the
Oh,
whole ceremony
you don't do the
is
Cyclops thing inside in the winter?
I had that set up and then I was just like, this sucks. Like I just
Oh,
think I didn't get into it. And I guess I'm not one of these people that's going to subscribe to a Peloton and have someone like, hey, go and cheer and you can do this. Like I actually do get outside and run in winter and so I've adapted to it. I mean, I lived here my whole life, so I'm kind of used to that. But still, like I would trade it in an instant. Like we went to Disney 4 years ago in like February. We drove down there, and I remember we left here. And it was like snowstorm and just it
yeah.
was horrible. Got down there and rolled the windows down on the outside of Orlando, and I'm like, oh my god, it's like 83 degrees and just like beautiful. But yeah, I'm not really into that whole indoor. Actually, I had that for my bike and I sold it to somebody. I put it on Craigslist. And
Oh,
I'm like, this thing's in great shape here if you want to buy it. And I think the guy paid me pretty well for it. Like it's like into training and stuff like that. I'm like, here, this will serve you well. But no, I just my it's a somber ceremony with my bike when I decommission it for the year. It's very sad. I should make a video about like decommissioning my bike because at the start of the year to bring my bike back to life, a it's like a battleship that's been decommissioned and then it like gets recommissioned. And you have to go through all these steps to bring it back and everybody's kind of happy but decommissioning is sad. I have to bring it downstairs and have a special place where I store it and cover it up and stuff like it's just bad. It's just psychologically, it's the whole day is gone. This is a day that I'm taking my bike downstairs for the winter. Just write that day off. Do all the bad stuff on that day. Just make that the bad day. Work on taxes, do things which will make you sad. Don't do anything good that day because it'll all be blended together and ultimately it'll be a bad day.
I loved my federal income tax course.
Just, I don't know. It is so, and I live in the southern part of the state. I grew up in the northern part of the state, which by this time of year has snow. And I talked to one of my friends in the northern part where I grew up. They're like, yeah, we have snow here. I'm like, oh God, glad I live like 200 miles south of that. But I absolutely hate it. And I think I was talking about this in my last podcast. I biked last Tuesday. It was 74 and sunny, very rare for October. So it was like my last long trek bike ride. And I got to this dam built in the 1930s, a conservation corps dam, and we already had a freeze, so a lot of the grass and stuff had died down around it. So I was like, I always wanted to check it out, so I did. But the problem with checking out a dam in that type of conditions is I had my bike shoes on, and my bike shoes are flat. Bike shoes aren't meant to have traction because you're not running on the ground, and they're not meant to have cushioning and all that stuff. So I had my bike shoes on and I'm walking across this dam, which is like, almost 100 years old. And it's been, like since the 50s, no one's been upkeeping it. I just wanted to check it out. But I almost fell like 3 times, literally. And each time would have been fatal. And you think after the first time being the safety doc, and granted, I didn't record any of this because I had to have like my full concentration on like not falling into this dam and perishing. Yeah, I would have like got the cue after the first one, like, oh, dude, like either like take the shoes off or like just don't do this today. I'm like, no, man, I always wanted to check out this dam. So yeah, after like, 3 near misses of like fatality on this dam, and then to get off the dam, I was like, there's only about a foot wide area to run across for a solid 10 feet. And I'm like, my best option is to accelerate as fast as I can, because if I can get in 2 steps on that, I can probably just lunge myself forward and land on the bank. And that was the plan I went with, and it actually worked. But yeah, I was thinking, this is dangerous. I should know better as a safety doc. And then, yeah, the safety doc legacy. He was done in by the curiosity of a 1930s dam. And the whole time I'm thinking, this is dangerous. I shouldn't be doing this. This is very bad. But there was some farmer on a tractor who kind of like paused like in his field and was looking. And he's like, "Are you going to go for it?" I'm like, "I'm going for it. My ID's in my bike bag here. So like if I don't make it, like they'll know who I was." And so like I'm kind of covered on those bases. But yeah, the whole thing was like counterintuitive. Plus, like I'm realizing I just don't have the actual skills that I had when I was maybe like 25 versus like my current age, my balance and things I had to like work extra into. But anyway, it was cool. Like I shouldn't say this, but I don't regret it. It was awesome to check out the inner workings of this dam. And I was just like, whoa, like this. I don't have any pictures to prove it or anything like that. But I don't know where that was going. But anyway, 74 degrees. It was warm. It was this exceptional day. I knew it was like my one chance. And because of the freeze, I was able to get close to this dam and get away from like the poison ivy and all the other stuff that would have been an annoyance, and bugs and snakes and things like that. I'm like, one time. Yeah, like literally had 3 close encounters with death on that excursion right there. So that's crazy. At least I don't know if there's dams by you, but man, they're great to investigate.
There's, I mean, I've been on the top of a dam, but I mean, it was kept up and had this nice pathway for people to walk along. And
wow. Yeah, that's different than the dam I was on, which hadn't been maintained for probably 70 years.
sounds
I was at Hoover
very
Dam in
different.
the year 2000, before all of the heavy restrictions with 9/11. I remember touring to Hoover Dam, and it was like one person leading the tour group, and there'd be like 30 of you, and I was like toward the end. There were all these levers and stuff. I mean, you could have messed with anything. Like you could have done anything. But I was walking across the dam and my sunglasses fell off my baseball hat. And the semi locks up all of the brakes and skids to a stop in the middle of the dam. And the guy's like, "Hey, go get your sunglasses." I'm like, "You could have run them over. Like, you didn't have to throw the brakes on and lock the semi." Thanks. I appreciate it. Weren't Ray-Bans, by the way. I got these at the store, but
At the gas station?
Thank you. He's like, no, go get them. Go get them. So yeah, that was, the I'm glad I did the Hoover Dam tour, because I've heard it's more restrictive now. Back then it was almost like a self-guided tour. I mean, it was just crazy how I remember that at the time. I'm like, God sakes, you're putting a lot of trust in me. I'm like, more trust than I would put at me at this age and time in my life. Granted, I'm not going to mess with anything here, but come on. I mean, at least pretend. No fanny pack. I don't think I did have a fanny pack by then. I did have a fanny pack, by the way. It was a U.S. Department of Geological Services green fanny pack. I still remember the color of it. Almost made at that time. Could also be on my tombstone. Yeah, the dam thing was iffy. I knew though that day going out that I was going to visit the dam if it was accessible. That lady is in the dam St. Priscilla. Oh God. All right, that means I need to sign up. All right, so
Full Rush, you should come and watch the Old Humble Happy Hour 2.0 on Thursday and see just how much of a saint I am.
All right, so Lisa, thank you so much.
Thanks for having me.
Indebted to your generosity of sharing your expertise and knowledge in this area, and you're always welcome back to the show. When we get to our 1000th episode show, I'll let you know. It's going to be a big celebration, but until then, Also, Thursday nights, you can find Lisa 9 p.m. Central Time on the Old Humble Distilling Company podcast on YouTube.
Mhm.
So you can enjoy her insight and her wit. And then also, what is it?
The Unhinged Chronicles.
The Unhinged Chronicles
Yeah,
portion.
for Bull Rush, I have been on Facebook dating because there's good material there.
So yeah, and just Bull Rush did share in the last week that he has embarked on some online dating adventures. He publicly did that on a podcast. So pretty wild times for our good friend Bull Rush in the state of Texas. So yeah, he said we
Oh,
should compare notes.
yes. Maybe we could have you on the Old Double Happy Hour.
He does have a 3-hour perimeter that he will, or 3 hours he will drive around him for a date, and after that, it doesn't matter. That's it. You have to be within his perimeter. But I believe he lives close to Joe. He lives in the Houston area because he said Joe is 30 minutes away from where he lives. So yeah. So and Joe from Old Humble said, "We're going to talk a murder podcast guest this week." Whoa. Yikes. It's
Hey,
scary.
Joe, is it B or CC? Totally didn't die for COVID.
Right. Yeah, I don't know. Right. Well, at least I know you have a cat that needs to be right here. Houston area is a big place. All right. Yeah. And I am coming down to the greater Houston area in spring. I'm first going to Salt Lake City, and then I'm going to New Mexico, and then I'm going to Houston. And I will reveal the reason for that trip once it comes to spring, which is very interesting. This trip, which has actually been in the works for years. It's a solo trip. It's just me. But yes, there will be a
Oh,
trip.
so this isn't a book signing trip?
I guess it could be a book signing trip.
I should go pick up my book from the
If your book is in, Lisa, please consider leaving a review
it's
on
just
Amazon.
that I work at home, so I never leave.
And for anybody out there, I have been stuck at the 43 reviews number for like months, which is just like weird. And so
Yeah,
obviously,
this is
like
gonna be like sending you my bio.
I have a new book coming out, and it's going to be released in April. It's done. The publisher's working through it, but they're timing the release for April. And by the time that releases, I want 50, cross my fingers on School of Errors to be out there. It's in hundreds of libraries, but people will email me and they'll say, "Hey, like I loved your book." And then I'll email back and say, "It's awesome. Will you leave a review?" And then they're like, "Sure." And then like they don't. And I understand it. Like but only even like 2 sentences saying like, "Hey, this made me think about things differently regarding school safety and whatever." And that would be great because it does make a big difference for me as someone trying to make a dent in a niche market. So, hey, oh my goodness, Old Humble. Well, actually, Joe, if you contact me, I will be able to provide you with a reviewer draft, which you could look at and review. I would appreciate it.
Yeah, but look at his next comment.
And you could actually put, "This book is the worst cookbook I've ever read, but the 5 stars is fine." Yeah, it isn't meant. It isn't right. It is. I'm fine with that. Right. I'm totally fine with that. And my publisher has been kind of stuck on the sci-fi theme with marketing in the cover. And I'm like, it's not a sci-fi book. It's about how humans interact during chaos. So we've got to dial it in a little bit. We've got to come to this merger. But the early artwork is a little Star Wars-ish for me. I don't know where we're at here. I'm not George Lucas, so it's not what the book's about. But anyway, all right, Lisa, you rock. I'll see you guys Thursday night over there on the Old Humble Distilling Company podcast. And everybody subscribe, like, share with friends. And we are out here on the Safety Doc podcast. Good night, everybody.
Bye.